Welcome, I am the loud little ducky. Today we are going over Owens v. Echard, the response to amended motion for relief based on fraud. And as the sign says, beware of lies, lies, and more lies. So let's exit and find out what they are. From David Gingras in the Maricopa County Superior Court, State of Arizona, petitioner's response to respondent's amended motion for relief based on fraud assigned to the Honorable Judge Matta in Owens v. Echard. Petitioner Laura Owens, Miss Owens, we are not calling her Miss Owens, or petitioner, respectfully submits following response to respondent Clayton Echard's Mr. Echard or respondent amended motion for relief from judgment based on fraud. As explained below, there has been no fraud of any kind in this proceeding. Yes, Owens had made misstatements along the way, including misstatements to third parties and at least one minor misstatement to the court in the order of protection proceeding. This is not a minor misstatement. A minor misstatement would be that you believed that this happened at 1 p.m., but you stated 2 p.m. That is a minor misstatement. Not all this other garbage. As explained below, none of the misstatements affected the outcome of the order of protection proceeding. Yes, they did. Nor do they have any effect on the paternity proceeding, except, of course, to the extent they bear on Owens' overall credibility, which she has none. None. Zero. It did affect it, because if the order of protection judge, which was Judge Duty, if he thought that she was lying and had no credibility, he probably wouldn't have granted it. Lying takes away a lot and could have changed the outcome of the protection order. It very well could have. As will eventually become clear once all the facts are known, even accepting the problems with Owens' credibility, there is no objective medical proof Owens wasn't. There is, sorry, I was reading it as a statement of fact, but I forgot we're stating lies here. There is objective medical proof Owens was in fact pregnant, and she believed with good reason that Mr. Echard was the father. Because she's Delulu? Thus, even accepting other unfortunate but unrelated problems with credibility, it's all related. Owens had a valid good faith basis to commence the paternity proceeding against Mr. Echard, and she also had a valid good faith basis to seek a protective order on Mr. Echard's abusive and harassing conduct. He was not abusive, and he did not harass you. You harassed him with over 500 messages, in which he didn't respond to half of those. One, procedurally prefaced. The posture of the current pleading... Oh, wait. No, we skipped a whole paragraph. For the reason the protective order previously entered on October 26, 2023, in the case had valid factual and legal basis, and there are no grounds to change that decision. Accordingly, Mr. Echard's motion should be denied, and Owens should be awarded her reasonable attorney fees incurred in preparing his response pursuant to ARS 25-324. No. She should get nothing except for a ticket straight to jail. Now we're in the procedural preface. The posture of the current pleading is somewhat confusing. It's really not, though. It's pretty clear. It's pretty black and white. Your client is what makes things confusing, because she keeps pulling stuff out of her rear end. So, in an abundance of caution, this response begins with a short comment to remove any potential misunderstanding. First, on March 26, 2024, Mr. Echard filed a motion for relief from judgment based on fraud in the order of protection matter. The initial motion was never served. The certificate of service indicates it was emailed to Owens, who was self-represented at the point, and had not agreed to accept electronic service. Well, you see, whether it was served properly or not, she knew when the hearing was, and she attended that hearing for the order of protection, and so by continuing it and getting a judgment in that hearing on the motion, she waived the thing for not being served properly, because they were both unrepresented at the time. Undersigned counsel was retained to represent Owens first in the paternity matter and later in the order of protection case. Upon appearing the order of protection matter on April 9, 2024, undersigned counsel filed a notice explaining that the previous motion for relief based on fraud had not been served on Owens and that no response was currently due for that reason. Okay. The issue of service was later resolved between counsel and undersigned and intended to file a timely response to the motion seeking relief based on fraud. Just accept the email to be served by email. Just accept it. She's just going to dodge it so that this case goes on forever. In the interim, Mr. Echard filed a motion seeking a joint hearing in these two cases, which this court granted via minute entry order issued April 26, 2024. Technically, the motion for a joint hearing was never properly served either, but Owens had no objection to that request. Exactly. She did not object. Finally, on April 26, 2024, Mr. Echard filed pleading purporting to amended his prior motion for relief based on fraud, although it appears the amendment was filed only in the paternity case and not the order of protection case. With that slightly complicated posture in mind, this pleading is intended to represent Owens' response to both the original motion seeking relief based on fraud filed in the order of protection case and the amended version of that motion just filed in the paternity case. Hope that makes sense. Introduction. Because of the order of protection case has been functionally consolidated with the paternity proceeding, a brief recap is in order. For yourself, I'm sure, because none of us need it. On October 6, 2023, I will blow raspberries every time I accidentally say Miss, because she deserves no respect on her name. Owens filed a short pro se petition asking for an order of protection against Mr. Echard. That's way after she supposedly miscarried those fetal sacs, right? So why? For her factual basis, the petition generally alleged Mr. Echard sent harassing and threatening messages to Owens expressing his anger and hatred towards her. Yeah, I think he has the right to feel that way right now. And I think he has the right to tell her he feels that way. Like, people can say how they feel. Owens further claimed Mr. Echard published harassing and annoying messages about her online and he encouraged others to do so. No, he did not. And I would like y'all to prove it. Because he did not encourage other people to harass and annoy her. Don't contact her. Don't wish her anything. Don't tell her anything. Just leave her be. Owens also argued that Mr. Echard posted messages online sharing private and confidential information about her, and again he encouraged others to do so. Where did he encourage them? Prove it. Because that didn't happen. And private and confidential information, you know what makes it not private and confidential information anymore? Is when you post it yourself, Owens, on a public forum for the Dropbox link to your private and confidential information. That makes it public and not confidential. But I would need you to have a bigger than a pea-sized brain to actually comprehend that. Owens claimed that these actions had caused her extreme anxiety. Oh, I bet. Posting a Dropbox link for people to see that she wanted people to see and talk about gave her extreme anxiety. Oh, are they going to believe me? Are they going to believe him? I hope they believe me. And fear for her safety to such a degree that she was afraid to leave her own home. Bullshit. She had no problem going to dinners, hanging with whatever friends, doing her podcast, going to horse riding competitions. Yeah. Oh, she also went to California's Planned Parenthood, supposedly, although I still think that image is from the Michael Maraschini case. It's still a lie. So no, she was not afraid to leave her home. She tried that, oh, I'm afraid to leave my home. I can't leave my home with Michael Maraschini. Which wasn't true because she was always going to Mamanoku. If you haven't seen my coverage on that, I will leave the link for the part 1, and then you can go from there. It is in the playlist of this case. After an ex parte order was issued, a contested hearing was held on the petition on October 25th, 2023, at which Ms. Owens and Mr. and Mr. Echard both testified. Following the hearing, the court found by a preponderance of the evidence that there is reasonable cause to believe that the defendant has committed an act of domestic violence within the last year. Basically, minute entry order 10/25/2023, filed 10/26/2023. Mr. Echard now seeks relief from this order, but only sort of. As a starting point and as a recurring theme, Mr. Echard argues plaintiff was never pregnant by defendant. Yeah, he does argue that. A point which was arguably litigated and resolved against him at the hearing. No, it wasn't. Because the facts that she doctored an image to get that protection order didn't resolve it, because it was a lie based on fraudulent documentation. No matter what part is fraud. All of it's fraud, in my opinion. Mr. Echard then proceeds to cite a handful of various fraudulent things done by Owens, including modifying a sonogram image. What? Are you saying that that's not true? Because she admitted that. And lying about what doctors saw her. Yeah, those were fraudulent things she did. Those have been proven already. Taken as a whole, Mr. Echard's motion seems to contain two main issues. First, he claims Owens was never pregnant. Yep. If true, that would potentially affect her statutory rights to seek relief under the Order of Protection statutes, ARS 133601 and 133602. Second, Mr. Echard claims Owens lied about things such as the authenticity of the sonogram image and other aspects of her pregnancy. Yep, she did. In the narrow context of an order of protection proceeding, it appears Mr. Echard is attempting to raise those issues to show that if he published medical record online, which did not belong to Owens. That means he did not engage in the type of conduct that would support the order of protection entered here. She's the one who sent it out. And when you send it to third-party people, it's no longer private. You don't want other people to have it because you can't control what other people do. That's your own thing. As explained below, none of these arguments are well taken. The order of protection was properly and lawfully issued, and no grounds exist to vacate or modify it, except for it's all based on lies. That seems like a pretty good reason to me. As such, Mr. Echard's motion should be denied, and Owens should be awarded her reasonable attorney fees incurred for preparing this response. No. Denied. Discussion. Arizona has many different laws permitting orders against harassment, threats, and other types of offensive conduct. The two main laws are ARS 12-1809, permitting injunctions against harassment, and ARS 13-3602, allowing orders of protection for the purpose of restraining a person from committing an act included in domestic violence. Except there was no domestic violence committed here. These orders/injunctions are typically focused on preventing unlawful conduct, but they also have the potential to impact certain constitutionally protected activities, including free speech. To ensure the right to engage in a vibrant discourse, it is not unduly chilled. Protective orders, injunctions are subject to strict procedural and technical requirements, including very specific statutory standards, which are necessary to protect the First Amendment right of the litigants, while still providing relief for the victims of harassing conduct. See Street v. Visor, 2015, Arizona. And it says vacating injunction against harassment on First Amendment grounds and noting a restriction like this based on the content of speech is permissible only if narrowly tailored to achieve a compelling state interest. Of course, Mr. Echard was not raised any sort of constitutional challenge to the order Owens obtained in this matter, so this response will not explain why the order is constitutionally improper or proper. Yeah, I don't even know why you need to put that in there. If you are following along in the What the Hales case, the Judge Grudge, had to go back and change it because he was infringing upon Jeremy Hale's First Amendment rights in the protection order. Let's see what else Gingras has to say. With this backdrop in mind, to the extent Mr. Echard claims he is entitled to relief because Owens was never pregnant, this appears to be an attack on the court's statutory authority to grant any relief at all under the Order of Protection statute. The attack is baseless, both legally and factually. I don't think it is. Because she got this fraudulently. She didn't tell the truth. She swore under oath and lied a bunch. She committed perjury. Owens was legally eligible for order of protection. I don't think anybody's saying she wasn't eligible. Like, I don't think that has come out of anybody's mouth. To begin, any party seeking an order of protection must show they are entitled to relief under the law, unlike a harassment injunction under ARS 12-1809, which may obtained by anyone regardless of the relationship between the parties. Orders of protection under ARS 13-3602 are limited in terms of eligibility. By definition, a party seeking an order of protection must show they fit within one or more of the categories described in ARS 1336-01A, which includes things like married couples, parents who share a child, and cases in which the victim or defendant is pregnant by the other party. Well, none of those apply here. A1, 2, and 3 don't apply. But the OOP law is not permitted to only marital or paternal relationships. ARS 1336-01A6 allows relief in any case where the relationship between the victim and the defendant is currently or was previously a romantic or sexual relationship. Emphasis added. So yes, she does qualify for an order of protection because they did have some foreplay and stuff. So legally, she is allowed to get one. But the thing is, she is not allowed to get one by lying and doing it on fraudulent documents. That's where the problem lies. Not that she couldn't get one if there was something really going on, but there wasn't anything going on. Here, fleeting as it was, there is no dispute Mr. Echard and Owens had a romantic relationship which involved some level of sexual contact. Yeah. Mr. Echard denies intercourse, but Owens claims sex occurred in addition to oral sex and other activities. Yeah. Nobody's denying that. Thus, even if Echard was correct, and even if Owens was never pregnant, that point is entirely irrelevant to her right to seek relief under the Order of Protection statute. A romantic or sexual relationship is sufficient, and we have both. For that reason, Owens did not obtain the order of protection by fraudulently claiming she was pregnant. Yes, she did. She did get it fraudulently by claiming she was pregnant when she wasn't. She didn't fraudulently get it because she lied about being in a relationship or having sexual stuff with him. Like, she had the right to get one, but that should not have been granted because she fraudulently claimed she was pregnant. Relief was still available under the law, even if Owens was never pregnant at all, simply based on the brief romantic rendezvous. I wish Clayton probably wishes he could forget that rendezvous. B. The court properly found the facts supported relief. I don't think... Did they? Yes, they found them. I don't... And at the time, with the knowledge that they had, I can see them giving it to her. Possibly. I still don't think any of it arises to any of that, but it's the fact she lied to get it. Aside from Owens' statutory entitlement to relief based on her relationship with Mr. Echard argues the order of protection was obtained by fraud because Owens was not factually entitled to relief she sought. Again, Mr. Echard's arguments are not well taken. As explained above, following a contested hearing, the court made a factual finding that Miss Owens established by a preponderance of the evidence that there is reasonable cause to believe that defendant has committed an act of domestic violence within the last year. Minute entry order 10/25/2023, filed on 10/26/2023. In evaluating that finding, it is critical to understand in the context of an order of protection hearing, the term domestic violence has a very specific legal definition. It says domestic violence means an act that is a dangerous crime against children as defined in these sections, or an offense prescribed in these sections and paragraphs and all that stuff. ARS 133601A. This long list of numbers means little to non-lawyers and probably nothing more to anyone else. The key to understanding this is the list includes an extremely broad range of conduct involving completely unrelated acts like negligent homicide and revenge porn, which neither happened in this case, so why are you talking about it? The statutory definition of domestic violence also covers things like recklessly parking any vehicle in such a manner as to deprive livestock of access to the only reasonable available water. Yeah, because certain animals are considered domestic animals, so they could go into that domestic violence category. A lot of times they don't usually charge it that way anymore. It's like animal cruelty or animal neglect, torture, things like that. But yeah, I could see why it would cover that. It's like, seriously, that meets the definition of domestic violence. Yeah, because that's cruelty to animals if you're blocking a water source from them. Animals need water. I'm glad you don't think animals, they're domestic animals. Nobody ever heard of that? Here, after the hearing, the court did not explain precisely which aspect of the domestic violence was proved. But we can rule a few things out. It is undisputed Mr. Echard did not park his car in such a manner as to deprive livestock of access to water. Phew! Nothing worse than thirsty cows. This is a face palm moment. Is he writing his motions and blogs and then just giggling to himself because he thinks he's so funny and clever? Nothing worse than the thirsty cows. Oh my gosh, it's so cringe. Stop narrating. Gingrich, just stop. Instead, given the allegations in Owens' petition, it is fairly clear the court's finding was based on ARS 132904, prohibiting disorderly conduct, and or ARS 132916, using electronic communications to terrify, intimidate, threaten, or harass. She was the harassing one. He was not being disorderly. Did he communicate electronically? Yes. I don't think he was trying to intimidate her or terrify her or threaten her. I don't think any of those apply. Both in her petition and in her testimony at the hearing, Owens established Mr. Echard sent her threatening, harassing, and insulting messages, and in the ex parte order entered on October 6, 2023, the court clearly was focused on Mr. Echard's online attacks and harassment, which are extensive and not limited to posting a single sonogram image. Other orders, the court finds reasonable cause to believe that the defendant may commit an act of domestic violence or has committed an act of domestic violence within the past year, or good cause exists to consider a longer period. Defendant shall have no contact with plaintiff other than as outlined herein, and shall not cause others to contact plaintiff other than as outlined herein. Defendant shall not communicate or post untrue or harassing comments regarding plaintiff online, including but not limited to on social media, and shall not cause others to communicate or post untrue or harassing comments regarding plaintiff online or otherwise. Well, nobody's over here posting untrue stuff. We're given some opinions based on the things that we see in court filings and that she's put out there for us. So, nope. No untrue or harassing stuff here. Because she doesn't have to come watch any of this. And none of us are contacting her. Notably, in Mr. Echard's motion for relief, he never even attempts to refute the allegation in Owens' petition, which addressed his harassing conduct towards Owens, including messages he sent describing his rage, hatred, and fury towards her, as shown below here. Yeah, he has the right to be mad at her and be angry. He didn't lay a hand on her. He is mad and angry and furious at what she is doing to him and has done to him for almost a year now. Says approximate date 6/1/2023. Clayton has sent threatening messages since discovering I was pregnant, such as, I legitimately hate you right now. Okay. My hatred will only grow if you decide to put me through all of this. Okay, he's telling her like it is. My animosity would last for a lifetime, and that's not something either of us want to subject ourselves to. One thing about me is when I make up my mind for good, especially when it's rooted in anger, I don't sway. Okay, so he will be angry, and he will hate you, and he will hold the grudge against you, as I think one should in this situation. I don't sway ever. My hate is towards you and you only. If you decide to not take Plan B, and in the wild event that you are pregnant, I would hate you even more. Why is he not allowed to express how he feels? If she was actually pregnant and he believed that she actually could be, is this a nice thing to say, or should you handle it differently? Yeah, you should. But considering who we're dealing with, and that he thinks that the sexual acts that they did don't equal pregnancy with his baby, I can see why he would be angered. September 21st, 2023. Clayton Echard was The Bachelor and has many die-hard loyal fans. Nobody is a fan because he is The Bachelor. I can't say that we're necessarily fans. Because we weren't like just Bachelor fans. Most of us that are talking about this case don't actually watch The Bachelor. I haven't watched The Bachelor in I don't know how long. It says he and I are involved in a very public paternity case. Who made it public? You made it public, Owens, by going to The Sun and all these other people. You made it public. The case that is being covered by every major media outlet, except for it's not really. Clayton posted to a story to his 270,000 followers to look me up, which they have. Okay. And I have been sent threatening and harassing messages by his followers. Okay, telling somebody to look you up if you don't know who she is or whatever, if you want to know who she is, you can look her up. That's not him saying, and I want you to message them and send her hateful things. That is not what that says. I explained this to him and asked him to take down the post, which he did not. By posting personal and sensitive information about me publicly and without my consent, he has made me feel humiliated and embarrassed. No, you have humiliated and embarrassed yourself, Owens, by all of this nonsense. And when you're putting the Dropbox link out there, that's your consent that you want this out there. When you email things to third-party people, They can now do what they want with it within the law. They can say, hey, look, guys, this was sent to me. Like, as long as it's not like your social and certain things like that, or it's not nudes and things, you gave it to them. So why can't they do whatever with it? Because it's now not private. You shared it with other people. This conduct, which has nothing to do with an altered sonogram, was sufficient standing alone to support a finding of actual or potential domestic violence within the unique statutory definition of the term. I don't think it is. Mr. Echard does not challenge that point. As such, even assuming Owens was not truthful about other issues, the undisputed evidence supported the order entered here on that basis alone. He goes on to say Owens was pregnant. Lies and lies and more lies. In his obsessive, never-ending quest to smear and defame Owens, just like Donald Trump did with writer E. Jean Carroll to his later financial detriment, the judge does not give a crap about what Donald Trump did to some girl. She could care less. Whether she hates him or she likes him, she does not care. Because Donald Trump doing anything with anybody is an image that's not an image we want in our heads. Nobody wants that. Mr. Echard claims that Owens was never pregnant, that she has provided no verifiable medical evidence to support her alleged twin pregnancy, and that every obstetrician and gynecologist plaintiff claimed to have seen has indicated they have no records, as she was never seen as a patient. What record does she have that said that they've seen her as a patient and verified a twin pregnancy? We've had pee sticks that show there's a possibility you could be pregnant. We've had a non-viable blood test with an HCG level of 102. That is not verifiable proof of pregnancy, and even if it was, it's not verifiable proof of a twin pregnancy. There is no verifiable proof. To be clear, each of these is knowingly false statement, which will result in a forthcoming motion for sanctions against Mr. Echard and his counsel. At some point, these constant lies must stop. Yes, they must. From you and your client, Gingras. Echard has not lied. He has said what the evidence shows. In the meantime, rather than pre-litigating the entire case in this pleading, oh, that's not what you're doing here? Owens simply directs the court's attention to an expert report of Dr. Michael T. Medchill submitted here with Dr. Medchill is recently retired Arizona OBGYN with more than 30 years of experience in the field. His curriculum vitae reflects that in addition to his medical degree, Dr. Medchill also separately holds a PhD in immunology and biology, a master's degree in microbiology, and a BA magna cum laude in biology. You know what I was? I was magna cum laude. I was also on the dean's list. You know what it really means to me now? Like, I'm proud of myself for doing it, but does it mean anything in the outside world? No, it doesn't. His work experience is even more impressive. During his lengthy career as an OBGYN in Arizona, Dr. Medchill served as a chairman of the OBGYN department at St. Joseph Health Hospital in Phoenix. Although not reflected in his CV or report during his long career. Why didn't he put that in his report? Dr. Medchill personally delivered more than 22,000 children, likely more than any other physician in the state of Arizona prior to his recent retirement. Okay? I don't know if he's had more deliveries than anybody. Is it possible? Sure. You gotta put in that little nice, humble brag. Dr. Medchill was board certified by the National Board of Medical Examiners and the American Board of Obstetrics and Gynecology. His education, training, and experience in the field are truly exceptional. He may be an exceptional OBGYN. He might be. I don't know. But he's being lied to in order to give his opinion. So, I'm not saying that this guy isn't credible. I'm saying where the information is coming from to give to this expert is not credible. Because I wonder if this guy looked at Echard's evidence, if he would have a difference of opinion. What does this guy not know? In his report, Dr. Medchill explained he has reviewed Owens' medical records, which are extensive, contrary to Mr. Echard's claims. I'm still not seeing any extensive stuff that points to anything. Maybe we haven't seen it all yet. But he better have a mountain hill that he hasn't shown anybody so far to prove that. And other evidence, including an affidavit from Owens describing her contact with Echard and her activities relating to the pregnancy. Not buying a word Owens had said. If this expert goes off of Owens' affidavit, he already has an opinion that is not based on facts, which discredits this expert's opinion because he was not giving true and correct information. Based on his review, Dr. Medchill's expert opinion is she was clearly pregnant with 99+% certainty based on 5 HCGs from both urine and blood. Her blood was not viable for a pregnancy. And P-tests don't count. Importantly, Dr. Medchill also directly refutes an extremely frustrating, inaccurate, and tired trope included in nearly every pleading filed by Mr. Echard. To wit, Plaintiff Owens was never pregnant by Defendant Echard, as they did not have penetrative sexual intercourse. Motion at 210-11, emphasis in original. On that point, Dr. Medchill explains human beings can and do become pregnant without penetrating sexual intercourse. Nothing. I have heard that story many times. But maybe the patient is lying to you. Now this patient that he brings up, it would be remarkable if she was lying, and these things were actually going on. If she actually did and just lied about it, the fact that everything is how it is truly, it's something to wonder about. Dr. Medchill provides a fascinating discussion about a patient he treated named Maria, who was confirmed to be pregnant despite claiming she had never had intercourse. Most would look at this and be like, what? No way. Dr. Medchill explained his physical exam verified she was pregnant, and her hymen was still intact. thus confirming she was, at least in the literal sense, a pregnant virgin. Now, can you have intercourse without breaking your hymen? Yes. If somebody just sticks it in, I know this is gross, but, and maybe doesn't do other things, just is sitting there, I can see how the hymen might not get broke, and the person maybe, I guess dribble, as Gingras likes to say. So nasty. I could see where that could happen. Is it a rare thing? Yeah. But I could see where that part could happen. Would it be reasonable for Owens to assume she was pregnant based on the type of sexual contact she had and the lab test results she should receive? Yes. I don't think so. And usually people don't just say, here's your lab test results. Usually the doctor will explain your test results to you, saying, yeah, it shows that you have a 102 HCG level, but it's not enough to say that you are pregnant. I feel like a doctor would say that to her. I don't feel like doctors are out here just giving blood tests and they're not explaining what the lab test came back as. At an urgent care in an emergency room especially. If that's what you're in there for. They would have explained that to you. There was not a description of foreplay, and there was disputed testimony about the afterplay. It is well known that men are like basketball players. They dribble before they shoot. Which is why the withdrawal method has a much higher failure rate than most other methods of birth control. Well, pulling out is not birth control. Let's just say that right now. That is not approved birth control. There's a lot of guys out there whose pull-out game is very weak. And that should not be considered birth control. Goes on to say they also dribble after they shoot. So if he did not put his P in or near her V after an orgasm, she could still get pregnant. The odds of getting pregnant obviously go down if the semen is released just outside of the V, but it is still possible. In fact, I had one patient who was clearly pregnant, ultrasound confirmed. See, we don't have an ultrasound confirmed in this case. We have a fraudulent one, but not a real one. She absolutely denied intercourse, denied ever using a tampon, and stated she was a virgin. I have heard that story many times. In this case, however, I was shocked at the time of her exam to see that her hymen was intact. That alone would be remarkable enough to remember. But her name was Maria, and her due date was within a day or two of Christmas. She is the literal version of Mary the Virgin. Thus, contrary to the wholly unsupported, self-serving allegations of Mr. Echard and his counsel, an OBGYN with impeccable credentials has reviewed the facts in this case and will opine at trial that Owens was not only pregnant, she was clearly pregnant with 99% plus percent certainty. Does he know that sonogram is doctored? Does your expert know that? Was that disclosed to him? I wonder if that changes his opinion. As if that evidence was not sufficient, equally notable is the expert report recently disclosed by Mr. Echard, a copy of which is also submitted herewith. For his part, Mr. Echard has disclosed to OBGYN experts. The first, Dr. Faye Elizabeth Justia Lindy, is a medical doctor and a professor who appears to have experience teaching in the field of obstetrics and gynecology, although the extent of her practical and clinical experience as an OBGYN is unknown. Her CV reflects limited work experience in the field other than as a professor. Okay. I think that professors, if they are teaching current OBGYN people, I think they have to stay up to date on the technology and current methods that are being used. I don't think they're teaching things from the past. So I think they would have to know. Also the fact that she is a woman. And has she had kids herself? I think that plays a big part. The second is Dr. Samantha Deans. Her work experience as an OBGYN, like Dr. Justia Lindy, appears to be primarily teaching as an assistant professor. In terms of practical work experience in the field, Dr. Dean's CV indicates she has spent approximately 19 non-consecutive months working as an associate medical director for Planned Parenthood in Pennsylvania and Florida. So she might know something about how Planned Parenthood works, which is not good for your client, because she can verify that your client is a liar when it comes to what happened at Planned Parenthood. Given their relative limited experience in the field, neither Dr. Justia Lindy nor Dr. Dean express any opinions about whether Owens was or was not pregnant. Indeed, telling nothing in their report ever comes close to refuting Dr. Medchill's opinion that Owens was in fact pregnant with a 99% plus certainty. Maybe Samantha Deans has also had a baby. Instead, Doctors Justia Lindy and Deans offer a lukewarm and strictly qualified opinion stating they cannot confirm Owens had an ongoing viable clinical pregnancy, which meets their technical definition of the term. So it says in the box, we cannot confirm by any objective data that Owens had an ongoing viable clinical pregnancy at the time in the last year. Clinical pregnancy is defined as a pregnant diagnosed by an ultrasound visualization of one or more gestational sacs or definitive clinical signs of pregnancy. You know what's a clinical sign of pregnancy? A baby popping out. Yep. Did you know that was a sign of pregnancy? That you were pregnant at one point? That you had a baby come out? The more you know, right? I don't think Gingras knows that, but we know that. In addition to an intrauterine pregnancy, it includes a clinical documented ectopic pregnancy. We have received no viable documentation of a clinical pregnancy as defined. So there's not a viable one, and there's not an ectopic one. There's no proof of it, which is why the fact that she says she passed 2 fetal sacs, but looking at those pictures, they're not fetal sacs. And Dave Neal just exposed they could have been photoshopped, which we know Owens likes her arts and crafts. But also, if you miscarry or you don't have a viable pregnancy and you start bleeding and things like that, especially if it's supposed to be twins, can you imagine what a twin ectopic pregnancy would feel like? Can you imagine the damage that that could do? And that if you started bleeding and things like that, you would want to make sure, especially if you're somebody with PCOS, that you go in and you get all that stuff cleaned out, because it can cause more damage. It can cause an infection. It can kill you. So the fact that nobody told her to go and make sure that you're okay, Even if it's just to say, yep, everything is doing its thing natural, but they're always going to tell you come back, in a week or so to make sure that everything is cleared out and good. Any doctor would tell you to go there. And if they didn't and they don't, they should lose their license, in my opinion. With all due respect to the doctors according to this bizarrely contrived definition, if a woman became pregnant and gave birth to a healthy child without ever having an ultrasound, Doctors Josiah, Lindy, and Deans would express the same opinion as they did with Owens' no viable clinical pregnancy. They didn't say just with an ultrasound. They said other verifiable means. Like a baby. That would be a verifiable means to show. But why, like mansplaining? Yeah, mansplain pregnancy and how it works to us and how it's verified. Mansplain that to us women, because we're just so stupid we couldn't even understand what we're doing with our bodies. According to their definition. In fact, by their definition, it is probably accurate to say undersigned counsel is not currently alive and writing this brief. No, I'm not going to say that. That's not appropriate. No, because you're clearly here. Sadly, you're clearly here and annoying all of us. This level of gamemanship speaks volumes about what is really going on here. But there is no need to speculate. The simple truth is Mr. Echard's own experts do not support his contention that Owens was never pregnant. They don't even try to claim this. I believe when they said there is no verifiable proof of an ectopic or viable pregnancy, that's within the last year. That states they do not think there is any documentation to show she was ever pregnant in the last year. You can't read unless somebody explains things Barney style to you. Instead, they simply created a bizarrely specific definition of clinical pregnancy and then suggest they can't conclusively determine whether Owens ever met the specific definition. Of course, the question of whether Owens had a clinical pregnancy or just a plain old regular one is not relevant. Making my brain hurt. A plain old regular pregnancy is a clinical pregnancy. Gingras. They're one and the same. Two peas in a pod. What the hell? Oh my God, what the hell? Like, what am I even reading here? As a matter of law, ARS 25804 does not limit paternity proceedings to only verifiable clinical pregnancies under the definition created by Mr. Echard's experts, and for the record, the issue is also irrelevant because Owens never claimed to have had a clinical pregnancy. Come in close, Gingras. Come in close. Listen. When she claimed she was pregnant with twins, she was claiming to have a clinical pregnancy. Ta-da! It's that simple. She just claimed she was pregnant. It's the same. Oh my God, how dumb can you be? As Dr. Medshill confirmed, she was, based on fake information in an affidavit, in my opinion. Maybe someday Mr. Echard will stop falsely claiming Owens was never pregnant, but sadly not today. He will never stop saying this until there is irrefutable proof, which there is none of that I have seen, that the public has seen. But we are waiting to see if on June 10th that irrefutable evidence comes forward. Because if not, and this is what we're basing everything off of, she was never pregnant. I am with Clayton on that. Never pregnant. The sonogram was not fraudulent. Okay. Whatever you say. Another tired point raised by Mr. Echard is that Owens committed fraud because the order of protection was based on a sonogram image that Owens has since admitted to altering. But this point does not in any way support the relief Echard asked for here. This is so for two reasons. First and most importantly, the order of protection was issued in this matter based on evidence unrelated to the sonogram. No, I think it had a lot to do with the sonogram. And if Judge Judy would have found out that it was doctored, it would have thrown it out and not even considered it. And would have considered that this woman had the audacity and gall to give a judge a doctored, fraudulent document, picture, whatever you want to call it. I think he would have some not so nice words to say to Owens. Once again, throwing candor to the wind, Mr. Echard argues the court explicitly stated the sole reason it was upholding the order of protection was because of the image containing the sonogram, motion at 8:23:24, emphasis in original. Owens' response is that no, that is not what the court said. And since Mr. Echard seems to have misused the court's ruling on this issue, it will be repeated here. Other orders, the court finds reasonable cause to believe the defendant may commit an act of domestic violence or has within the last year, longer period, don't harass, comments, all that. We already read that. The fact that the court ordered Mr. Echard to refrain from posting untrue or harassing comments regarding plaintiff online shows the order was not based solely on the sonogram image. Well, if that was a fake sonogram, I think it has something to do with it. But there's also other parts to that order. And it might have persuaded the judge another way. But we wouldn't know that because she lied right off the bat. And how are we supposed to believe anything else this woman says or does? We can't. It was based on Mr. Echard's relentless attacks against Owens, trying to falsely portray her as a pregnancy faker. Well, if the shoe fits. A campaign which has been extremely successful. Included in those attacks was this offensive photo showing Owens' body photoshopped on a fake Halloween costume package. This image, and somebody is mowing. That's wonderful. I am so sorry. This image is attached to Mr. Echard's motion as Exhibit 3. Owens didn't post this. Somebody else did. I'm assuming on Reddit. And I believe I made one of these too. It might be on my community page. I think I did it at Boozy. But this is funny. This is something that was trending and everybody was doing. It's a joke. Get over it. Although this image is fake in the sense that Owens has never appeared on a Halloween costume package. Thank God for that. Mr. Echard offered no evidence to show that Owens created this image or that she was responsible for posting it online. Given the embarrassing and insulting nature of this image, it stands to reason Owens had no reason to create this image or to share it online. I'm pretty sure she has created fake Facebook profiles and secreted Reddit accounts and different things to try to put it out there, along with possibly creating and being Chase J. Jones, all to try to get Clayton in trouble. So she could have created this to try to push her narrative. Indeed, the whole point of Owens seeking an order of protection was to provide relief from these types of attacks. Yeah, but Clayton was not the reason for them. Her evidence and lies are the reason that people don't believe her. Nobody should be attacking her. Like by contacting her. Speaking about public court cases is not an attack. It's just simply stating an opinion based on what we are reading or seeing. In short, Owens has admitted to modifying one sonogram image in a non-material way. Oh my gosh, the mowing is ridiculous. She testified in her deposition that she changed the name of the facility on the image to prevent Mr. Echard from knowing where it was done. Beyond that, Owens has always maintained that the ultrasound image itself was not fake. It depicted her body and it was taken at Planned Parenthood during the pregnancy, which gives rise to this case. And Gingras, you still have not done your due diligence to verify that what your client is stating is true. And I don't think you want to, because then it will be irrefutable proof that she has made you lie and look like a dummy in all of these documents. You're not going to go searching for the truth because as far as you know, you are just going off of what she tells you. Kind of like when a defense attorney is going to be defending a killer. The defense attorney is not going to go and look for evidence to verify that he is telling the truth when he says, I didn't kill that person. As far as this attorney knows, he's saying he didn't, so that's what I'm going to defend. Because if he actually goes out there and finds out that he actually is the killer, or he finds out that she actually didn't get an ultrasound from Planned Parenthood, he has to admit that his client is a liar and get off this case. Because he cannot go lie to the courts. But we know he knows that she didn't get this ultrasound at Planned Parenthood because he pays attention to people online. So he knows. He's just choosing to turn a blind eye. It simply means Owens made a very dumb decision to alter the document in a way that ultimately only harms Owens' case. But lying about the location where the image was created changes nothing about the fact that Owens was indeed pregnant. It does. Because we know she didn't get it at Planned Parenthood because they don't do ultrasounds at that one. We also know that she didn't get it from Smile, which is what the sonogram she doctored says. So if she didn't get it from Smile, and she didn't get it from Planned Parenthood, where did she get it from? Where did this ultrasound come from? Because it's not from either one of those locations. So that is a question that is not answered, and I don't know if that will ever be answered. But she did not get this in any of the means that she has said she has. Furthermore, Mr. Echard also admitted to lying in this case. He lied to Owens about a real estate agreement she asked him to prepare on her behalf. No, he did not. No, he did not. He said, I don't think I should be your realtor anymore. And that he passed on these agreements to somebody else so that they could prepare them. He told his boss. He also told the bar. Had to prove it and give his story. And the bar found him to be credible. Didn't like that he slept with the client, or not slept with the client. He didn't sleep with the client, but got involved with the client. And this caused this. That was a bad move on his part. But he didn't lie and say that he prepared these on her behalf. He said he doesn't think he should because of the situation he put them into. The fact that Echard has admittedly lied to Miss Owens does not mean he should automatically lose this case any more than the Sonogram issue shows Owens should lose. These are not one and the same. That was, he crossed the line with a business personal relationship. And he tried to fix it so she could get what she wanted still, but she refused to have anybody else do it. But he took a step back because he knew he had crossed the line. And someone who is doctoring photos and lying about being pregnant, I think that shows automatic loss. They are not one and the same. They are not equal on any level. Both parties in this case have acted stupidly at times. That is an unfortunate fact of life, and he who is without sin shall cast the first stone. You seem in your little head, Gingress, David, that you don't think you sin ever. It's always everybody else's fault. Everybody else has to be lying and making stuff up. You're not being the unprofessional one, the unethical one, the liar. So, are you going to cast the first stone, Mr. Perfect? Such a narcissist. The bottom line is that Owens concedes she made a mistake here. That's not a mistake. That is not an oopsie. A mistake would be like, oh, I grabbed the wrong sonogram. Like, I have 2 kids. And so if I was bringing something into court and I mistakenly grabbed my son's sonogram instead of my daughter's, and I submitted that one along with copies of my daughter's, but I had one mistakenly in there from my son because I keep them in a similar location. That's a little bit of a mistake there. What she did was an active, with malicious intent, doctoring of evidence. It was not a mistake. It was an intentional act. She could not provide verification that her story about the sonogram is true, and she understands this is an issue that may affect her credibility, to which she has zero. At the same time, it is important to note that even if the sonogram is completely ignored, there is still substantial and other objective verified proof to support her pregnancy claims. I can't wait for you to show us these. He's a lot of talk, but he don't really ever show us anything that can't be debunked. Because so much other proof exists, the sonogram becomes largely irrelevant. Notably, because the sonogram is disputed, Dr. Medchill completely disregarded it in his report. Yet he still concluded sufficient other evidence exists to support Owens' pregnancy with a high degree of medical certainty. No, I don't think it does. Because he was not given proper evidence. And did you not include it in your report? Like, did you just say there was an ultrasound and not give it to him? Or did you say, there was an ultrasound that she got, but because she doctored the information on it, we don't want you to put that into your opinion? Did he choose to disregard the information, or did you purposely make it to where he had to disregard it because he doesn't know about it? Conclusion. For all the reasons stated above, there is no basis for this court to vacate the order of protection entered in this matter. Reasonably factual grounds exist to support the court's finding of actual or potential domestic violence. I disagree, as the term is defined in ARS 133601, and Mr. Echard's motion fails to show any basis for a different conclusion now. I think he deserves the stuff to be dismissed. I think Greg does. I think Michael Maraschini does. And anybody else who has anything on them because of this liar. As such, Mr. Echard's amended motion for relief based on fraud should be denied in its entirety, and Owens should be awarded her reasonable attorney's fees incurred in preparing the response pursuant to ARS 25324. No attorney fees for you. You have wasted almost a year of everybody's time because of your lying and lollygagging and doing everything to delay this case because you don't want the truth to come out. But it's come out, and it's going to keep coming out. This was dated April 26, 2024. Copies were sent to Greg Woodnick and Isabel Rainey, and it is signed by Gingras. That is where we are going to end this particular video. I hope you enjoyed it. If you did, hit that like button. If you want to make sure you're notified for the second part of this, where we go over Dr. Medchill's opinion and credentials and such, hit that subscribe button and turn your notifications on. But we are going to end with our quote of the day, and it is: gaslighters avoid responsibility for their toxic behaviors by lying and denying and making you question facts, your memory, and your feelings. Which is exactly what Owens did to Clayton. In the beginning, the fact that she was doing all of this stuff, he actually was questioning his own knowledge on whether a person could get pregnant in the way that she described and in the acts that they did, according to him. If he is telling the truth, which we know so far, things that people have said about Clayton, and this woman's not the first person to lie on him. He is honest. And sometimes his honesty makes him look bad, but yet he is still honest about it. He is upfront. And that is commendable. because you don't find people like that very often. There's not a lot of those around, being honest to a fault. And so, please don't gaslight other people, and be aware of people trying to gaslight you. Know that what you know is true. Your memories, your feelings, and the facts in your mind all have value. And don't let somebody try to lie to you and tell you the sky is green when it is not. That is it for me, and I will see you in the next video. Bye!